Alrighty, folks, looks like we are live. I'm George, co-founder of SoloSuit. Sorry for the wait. We're going to go ahead and get going. Glad to see lots of people here. A lot of people attend this webinar every week, so you're not alone here. A lot of people get sued for debt, and a lot of them come to SoloSuit to get the help they need to respond. All right, so we're going to go over some of the basics on how to respond to your debt collection lawsuit. You're here probably because you've been sued for a debt recently. We're going to go over the basics on how to respond. Then we're going to reserve most of the time for Q&A. So if you have a question, go ahead and put that into the chat. Our great assistant, Hannah, will be responding to some of those questions in the chat in text. I'll also be responding to those questions verbally here on the webinar. All right, so just a little rundown on how this works. So if you've been sued for debt, you have received a summons and complaint or a petition and a citation, depending on what state you're in. You need to respond to that document with a formal answer document, response document, which needs to be filed in court properly. You can use SoloSuit to do that. Most people will do is they come onto our site and they click reply to a debt lawsuit button. You can check out some of our reviews. We have a 4.7 star rating on Google. Had a review recently from Ernesto. What a service. They explained all my rights so that I could make the best decisions possible. Found SoloSuit on YouTube, like you guys, maybe, huh? Which led me to the website. SoloSuit is a miracle, heaven sent, and a blessing with the cross sign. There we go. Ernesto, here to help you out. All right, so that's just one nice review. Got another review here from Lily, 5-star review. I won my case using SoloSuit. There we go. Happy to hear it, Lily. Very glad to hear it. So you just click the Get Started button. They'll ask you to make an account. You just put in your email address and your password. That's all we need for your account, just to save your progress on the answer. And then you're going to go ahead and progress. You're going to tell us what state you're in. And then on the next page, you'll be able to choose like what document, what package you want to do. A lot of people are doing the premium package because they want the attorney to review. You can do the standard package if you'd like as well. We'll file for you with the standard. If you want to have an attorney review your document, you can do the premium. Once you're done with the answer document, I'll put you out here. You'll have to upload your complaint and summons. Like you can take a picture of it and then upload that as you're doing the answer. If you want to settle your case, which most people do, you can click the Learn More button. Once you're done with your answer document, that'll take you over here to Solo Settle. Click the Get Started button. Again, you just answer a few of the same kind of questions. And then you'll answer some of the same questions, tell us like who the attorney is. You'll be able to tell us how much the lawsuit is for and how much you want to offer to settle. We'll take that offer, we'll package it up, and then we'll engage the software. We don't have people doing it, just the software will engage with the collector to work out like an ideal settlement for you. And then once you and the collector have agreed upon an amount, the collector will send the settlement agreement. You'll be able to sign it through our app, and then you'll pay the settlement amount and get that all wrapped up. All right, so that's how that works. That's like the basic overview on responding to your lawsuit and then settling. All right, just a little quick recap here. It's not what we want here. Okay, so usually you'll get the summons and the complaint. All right, and then you will you'll respond to that with the answer document. And then once you respond with the answer document, you can then make an offer to settle. Responding with the answer document is crucial. It gives you leverage needed to settle. And with settlement, you can use Solo Settle to get that done. There's a service called Solo Settle Assist right now. We recommend doing that. You can click the link at the end of Solo Settle and you can activate a partnering law firm that will work and help get this settled for you. All right. And the answer document is on like kind of how we think of it as solo suit. All right, so that is the quick rundown. We got lots of people on here, so make sure you get your question into the chat. I'm going to start working on the chat right now. All right, first question up is from Fancy. I missed my court date now. They have ruled in my debt collector's favor. What should I do? That's a tough spot. It's a tough spot. Sorry to hear it, Fancy. So you filed an answer, it sounds like, and then you didn't settle, and then they got a judgment against you, is what that's called. Okay, so they got a judgment because you didn't show up at court. It's pretty common if somebody doesn't show up at court, then the judge is probably just going to rule in favor of the person that showed up. So I'm sorry to hear about it. If you filed an answer, which you probably did because you got a court date, once you file an answer, you might get like a court date, and then there's judgment after that. There's probably not much you can do. You can try appealing it, but that probably won't work. You can try filing a motion to set aside judgment, but the judge probably won't grant it because you didn't show up at court, unless you have like a really good reason for why you weren't able to show up at court. So you can try appealing. There's probably no attorney that will like do that for you because it's a long shot. We don't do that for people either. Or you can try a motion to set aside judgment. A MSA is what we call it. So motion to set aside. Motion to set aside is a document that asks the judge to basically give you another chance. Okay, a motion is like a document filed in court that asks the judge to do something. In this case, it's motion to set aside judgment. So they're asking them to set aside that judgment. All right, you can just list your reasons why you can do that. If you really want to try it, you can email us. We do have a template that you can use. It's like a little bit of a beta template that you can use to generate that document. And then besides that, if you want to settle, you can still try settling. Collectors will actually settle even if there is a judgment, even if they do have like a writ of garnishment. Surprisingly, collectors will settle. So after they get the judgment, they're going to try to garnish your wages. So they'll file a writ of garnishment in court, find out who your employer is, and then take part of your paycheck from the employer. If you don't want that to happen, you can try settling, though you'll probably require a balance and full settlement, but you might be able to get a lower payment than what they will garnish, right? So federal maximum for garnishment is 25% of your income, more or less. If you settle the balance in full, so like if you owe $10,000, if you settle for that amount, you might be able to get it spread out across monthly payments of like $100 a month, which will probably be less than whatever they're going to garnish you at. So you could try that out. Maybe that is a path. All right, Miss Peaches, the judge granted my motion for discovery to plaintiff. It has been 30 days, but plaintiff hasn't provided requested documents. What's my best option? That's interesting. Okay, so it sounds like you were sued for debt. You got the summons and complaint, and then you filed an answer, and then you filed a motion for discovery. Alrighty, so motion for discovery is what we're looking at here. So that sounds like you're trying to begin discovery. I'm not exactly sure what a motion for discovery is in this case. Like usually you'll begin discovery by filing interrogatories or request for admissions. Motion for discovery might just be the beginning of that. Maybe you had to file interrogatories and request for admissions as well with the motion. You might want to look into that. But if you request the documents and haven't provided it, every court, like state, has different rules on how long they have to provide it. It probably is about 30 days in most cases. If they haven't done that, then you can file like a motion to dismiss for lack of prosecution is something that you can try out. So if they didn't respond, then you can do another motion. Motion to dismiss for lack of prosecution. That's what that is called. So basically, you're saying they aren't doing anything on this case, so it should be dismissed. Sounds pretty reasonable. You can try that out. You can also try settling still. Even if you win the case, they might only dismiss it without prejudice, so they might sue you again for the same debt. You can try getting it dismissed, or you can try settling. All right, floor. I sent my answer in and received the discovery papers. There was no timeline. It's been a month. I'm sending the papers back tomorrow. Interesting. So it sounds kind of like a similar situation as Miss Peach's. Sounds like you got the complaint summons, you filed the answer, and then you basically you got discovery. So instead, with Miss Peaches, she started discovery. It sounds like the plaintiff started discovery. That's more common. That's pretty normal. And then you sent in, you're sending in those papers tomorrow. It's been a month. Yeah, it'll probably be accepted. Uh, and then you can move forward, right? So if you want to try winning this lawsuit, you can try taking it all the way to a hearing and then saying that the collector should lose because they can't prove that you owe the debt. What's usually a better option for most people, especially if they owe a portion of the debt, like if they believe that they owe some of it, is to try to get it settled, right? So if you're in discovery, you can try settling pretty much at any point in time, right? So even if you're in discovery, you can try settling up until really you're in court, even like the minute before you're in court, you can try settling. Sometimes if you show up at court and my judge might say, have you guys tried settling? And you say, no, we haven't. Then the judge might say, all right, take a minute, try to settle out in the hall and get this thing wrapped up, right? Because most people want to settle. So settlement is a good option here. All right, let's see. Schnookums. I filed my response to a summons that is tomorrow through SoloSuit, and they have received the papers. Should I be showing up to the summons tomorrow even though I filed my response? Okay. So basically the summons is a document that tells you that you're being sued. The complaint tells you why you're being sued. I guess with the summons document, yeah, you are being summoned. Like technically it's summoning you to court or it's summoning you to respond. If there is an actual, the language can be kind of tricky. Usually on a summons, it's saying you need to file a written response by a deadline. Like you have 21 days to file a written response. They might use the word appearance. Like you might have to file an appearance. That means you have to file a written document. Usually, only in a minority of states is there a court date set in the summons. You might want to try calling your court and seeing if you're supposed to show up or if you just have to file a written response. If you want to be safe, you might as well try showing up and seeing if there's a court case for you on that day. You can also try looking online. Maybe Hannah can put in our case status search. We have indexed all of like the websites for the online dockets for different courts. Your court probably has an online docket, and you can see like, is there actually a hearing tomorrow? Usually, if you show up at court, usually if you need to show up at court, they use the word hearing. Sometimes trial, but usually like a hearing is when you actually have to show up at court. Alrighty, jumping back into the questions, we got Eric. Going into a virtual arbitration soon with LVNV funding after filing a motion to compel arbitration. It's exciting. Plaintiff only has copies of statements saying the amount I owe, but it is not itemized. What can I argue? Okay, interesting. Interesting. So Eric, the play with arbitration. So right, if you get the summons and complaint, then you file an answer. You can try settling. After filing an answer, you can try doing a motion to compel arbitration. All right. Usually the play there is to file a motion to compel arbitration, triggering the arbitration clause in your credit card agreement or your loan agreement. And then that clause will require the plaintiff of the lawsuit, the person bringing the lawsuit, to pay for the arbitration. Usually it's JAMS or AAA arbitration, which costs a few $1,000s to run the arbitration. So usually the play is that you're hoping that the collector won't pay that money and they'll just drop the case. It sounds like in this situation the collector has paid the money and they're planning on going forward with arbitration. They probably wouldn't do that unless they really think that they can prove that you owe the debt in arbitration. So you might be going into a situation where they have like a really compelling case. Also, it's important to know, so like doing arbitration is usually a good plan, usually because the collector won't pay for the arbitration that actually happened. But if they do pay, it's important to realize that the arbiter, some people, JAMS AAA, of course, is going to say that they are like neutral arbiters. There's ruling in favor of justice and stuff. But some people would say that since they're actually being paid by the credit card companies, they're actually going to rule in favor of the credit card companies more often than not. So that can be a little bit tricky, right? So you might want to consider that and watch to see if that's happening. It might be the case where like the arbitration company is essentially in the pocket of the person who's paying for the arbitration, which is the credit card company. That said, arbitration is like way easier to deal with and way easier to navigate than a court case. And there should be a pretty solid chance of you winning, especially if you don't owe the debt. If you don't owe the debt, you should totally win. If you do feel like you owe part of the debt, then you might want to try settling still, even before the arbitration begins, so that you might not have to pay like the full amount. And then in the arbitration, basically the same stance as in with a court once you're in there. You want to just make it clear that they can't prove that you owe the debt. They have the burden of proof. You don't have to provide like any new information. And you just want to try to say they can't prove it. As far as like an itemized list, I'm not sure that they're going to need an itemized list. If the person, so the NV probably bought the debt, you might want to make it clear that they can't prove that they actually have like proper ownership of the debt or they have a right to collect. Oftentimes there's something lost in that transfer between the original creditor to LVNV. All right, so that's a situation right there. All right, but oftentimes, debt collectors, they are trying to do things legitimately oftentimes, right? So they might have a good case. So you might want to settle before arbitration. All right, Elizabeth, I have and we have about 5 minutes left. We usually end about half past the hour. So I'm going to try to go rapid fire. I have an arbitration meeting. I'm being sued by a credit union. All other credit card companies are working with a debt relief company and are negotiating. Credit union saw money in my son's account and wants me to use this money to pay my debt. While I represent myself at a hearing, what should I say or not say? That's so intense. Well, I'm not sure if it's totally legal for them to see what money is in your son's account. Also, it's your son's account, not your account. So you can always bring that up as like a point, like your son doesn't owe the debt. As like a point of defense, really. What should you say or not say? Just remember, it's up to them to prove that you owe the debt, and try to make it clear that they can't prove like definitively that you are actually the person that owes this debt. All right, and then again, you can always try settling before arbitration. Floor, can Solasuit help me out even after I have sent my answer? Not see a customer service line in the contact to discuss any options. Yeah, our email is support@solasuit.com. Yes, once you file an answer, we recommend that you use our settlement tool to get the thing settled. Christina, I have court tomorrow for a credit card debt. What are the do's and don'ts to negotiate the debt with Discover lawyers? Okay, you filed through Solasuit. That's great. Glad to hear. You might want to settle before you go into court. Again, basically, this question's come up a lot today. I just want to make it clear that they can't prove that you owe the debt. We have a long video on this if you search on YouTube. I think on the thumbnail I'm like wearing a suit, so you can watch me in a suit talk about going to court. You can check that out. I'm with DMP. This is David. I'm with DMP. My only income is Social Security retirement. Uh, what is DMP? I'm not sure what that is. Let me just look that up real quick. Uh, yeah, I'm not seeing anything for like what. Probably some government acronym, I'd guess. A debt management plan, maybe. Okay, yeah. So sometimes collectors will try to garnish Social Security income, right? Oftentimes it's like prohibited for them to do that, but sometimes they might try it. You'll want to respond if you are being sued. You want to file an answer no matter what, and then you probably want to try to get it settled. Uh, okay, moving on to the next one. Tessa. Ah, nope. I think we already answered that. Uh, Dixie said blessings from Cheyenne Wells, Colorado. Thank you, Dixie. Appreciate it. Looks like Hannah's gotten into a lot of these questions here. Uh, Uttarakhandi, can I represent on behalf of my spouse? That's a good question. You probably can to some degree. I guess like you can certainly use certainly people use solo suit to create an answer document for a family member and then like file it through our service and pay for it. Uh, can you show up in court for another person? That's a little bit of a tricky question. You might need like power of attorney. Um, you might need like power of attorney document. Usually only a lawyer can represent someone in case. Um, yeah, so usually you can't show up in like court for someone else unless you're a licensed attorney. Maybe you could get like a power of attorney document to show up for them, depending on the case and like the jurisdiction. All right, moving on. Echo. May motion to compel arbitration was denied. Sorry to hear it. Due to no evidence of arbitration and contract as granted a continuance or more discovery. Not sure if the law group owns the debt. What could be a good next move? Probably trying to settle, right? So you can make an offer to settle using solo settle. Oftentimes you see debts settle for even like 45%, right? So if you owe 10,000, you might settle for 4,500 on like a lump sum payment. All right, so you could save a lot of money. That's usually a good choice. All right. Ofori. Looks like Hannah answered those questions. Uh, Car. How long does it take after filing for debt collector to serve papers? They came to my house, but they wouldn't leave papers with anyone but me. I haven't been back, so I can't file an answer yet. Okay, that's a good question. So, if you know a lawsuit has been filed against you, I'm not sure how you know that, but maybe you saw it online that it's filed against you. You don't want to avoid service. If they can't serve you, they'll find some way to say they served you. Either they'll like serve your neighbor, or maybe they'll act like they served you, um, or they'll just find a way to serve you totally legitimately and properly, right? Sometimes, if they can't serve you after like a month, they might be able to publish it in a local newspaper and call that service, right? So you don't want to avoid service. If you know the answer is filed, if you know the complaint's been filed and you see that online, you can just download the complaint from online on the docket, and then you can use that to create your answer document. Right. So that's an important concept. So you just want to get that complaint and then file an answer. Alrighty. So let's see. Last question here. We've only got time for one more. Trying to find a good question here. Does your company provide the negotiation service for the settlement? Yeah, so how it works is basically, this is like a pretty regulated area. Uh, so how it works is people use our software to negotiate the debt on their own with the collector. So the software enters you into like a structured negotiation process. We take a lot of like the guesswork and the confusion and the uh, like antagonism between the two parties out of the process. So you just say like how much you want to settle for, and then the attorney says what they want to settle for, and then you can counteroffer or accept. That's how it works right now. We make it real easy and take a lot of the difficulty out of the process. All right, so you can make an offer on Solo Settle. It's totally free to make an offer, and that's a wrap. All right, that is the overview on how to respond to your debt lawsuit. Glad we can answer your questions. I'm George with SoloSeo. I'm one of the founders. Please always remember that we are rooting for you. We're doing everything that we can to help you win your lawsuit, and we hope you guys win. All right, I hope you guys get the outcome that you are looking for.